Welcome back, future criminologists. In this video, I will be discussing the right to privacy. Let us define first the word privacy. Privacy is the state or condition of being free from being observed or disturbed by other people. It is the state of being alone or the right to keep one's personal matters and relationships secret. By that, what is then the right to privacy? The right to privacy refers to the concept that one's personal information is protected from public scrutiny. The right is also known the right to be left alone. In context, the right to privacy means the right to be free from unwarranted exploitation of one's person or from intrusion into one's private activities in such a way as to cause humiliation to a person's ordinary sensibilities. Nature of the right to privacy. The right to privacy is a basic fundamental human right. However, the right to privacy or the right to be let alone, like the right of free expression, is not an absolute right. What is protected by the right to privacy? The interest sought to be protected by the right to privacy is the right to be free from unwarranted publicity, from the wrongful publicizing of the private affairs and activities of an individual, which are outside the realm of legitimate public concern. Reasonable expectation of privacy test. This test determines whether a person has a reasonable expectation of privacy and whether the expectation has been violated. The reasonableness of a person's expectation of privacy depends on a two-part test. 1. Whether by his conduct, the individual has exhibited an expectation of privacy. And 2. This expectation is one that society recognizes as reasonable. By these two tests, the reasonableness of a person's expectation of privacy must be determined on a case-to-case basis, since it depends on the factual circumstances surrounding the case. Instances when intrusion to the right of privacy is allowed. A limited intrusion into a person's privacy has been regarded as permissible, where that person is a public figure and the information sought to be elicited from him or to be published about him constitute of a public character. Example of public figures are public officials who work for the government. Briefly put, the right to privacy cannot be invoked to resist publication and dissemination of matters of public interest. Examples of intrusion. 1. A regulation mandating the opening of mail or correspondence of detainees is not violative of the constitutional right to privacy, as long as the letters are not confidential communication between the detainee and his lawyer. The detention officials may read them. But if the letters are marked confidential communication between the detainee and the lawyer, the officer must not read them, but only inspect them in the presence of the detainees. By the very fact of their detention, they have diminished expectations of privacy rights. 2. A government employee charged with a crime in connection with his office does not have a reasonable expectation of privacy in his office and computer files. The Supreme Court ruled that government agencies, in their capacity as employers rather than law enforcers, could validly conduct search and seizure in the governmental workplace without meeting the probable cause or warrant requirement for search and seizure. Next, I will discuss right to privacy in social media. To address concerns about privacy but without defeating its purpose, Facebook was armed with different privacy tools designed to regulate the accessibility of a user's profile as well as information uploaded by the user. It is through the availability of said privacy tools that many online social network users are said to have a subjective expectation that only those to whom they grant access to their profile will view the information they post or upload thereto. This, however, does not mean that any Facebook user automatically has a protected expectation of privacy in all of his or her Facebook activities. Before one can have an expectation of privacy in his or her online social network activity, it is first necessary that said user manifest the intention to keep certain posts private through the employment of measures to prevent access thereto or to limit its visibility. And this intention can materialize in cyberspace through the utilization of the online social networks privacy tools. In other words, utilization of these privacy tools is the manifestation in cyber world of the user's invocation of his or her right to informational privacy. Halimbawa, yung post mo ginawa mong open quote, only me, close quote. Next, the applicability of the exclusionary rule to the right to privacy. Any evidence obtained in violation of the Constitution, take note that the right to privacy is protected under our Constitution, shall be inadmissible for any purpose in any proceeding. Remember, however, that you can only invoke this if the government is the one interfering your rights. There is an exception which I will discuss next. Can the exclusionary rule be applied as against individuals who violate the right to privacy? Yes, although generally, the Bill of Rights can only be invoked against violations of the government, the Supreme Court has recognized an instance where it may also be applied as against a private individual. The facts of the case are as follows. The wife entered the clinic of her husband, a doctor of medicine, and in the presence of her mother, a driver, and a private respondent's secretary, forcibly opened the drawers and cabinet in her husband's clinic and took 157 documents consisting of private correspondence between her husband and his alleged paramours. The documents and papers were seized for use in evidence in a case for legal separation and for disqualification from the practice of medicine which the wife had filed against her husband. The issue is whether or not the documents and papers in question are inadmissible in evidence or whether the act of the wife are in violation of the husband's right to privacy. The Supreme Court held that the documents are inadmissible. Please listen to this, ladies and gents, future husbands and wives. The Supreme Court said that the intimacies between husband and wife do not justify any one of them in breaking the drawers and cabinets of the other and in ransacking them for any telltale evidence of marital infidelity. A person, by contracting marriage, does not shed his or her integrity or his right to privacy as an individual, and the constitutional protection is ever available to him or to her. Sa madaling sabi, kahit may asawa ka na, may privacy ka pa rin. Pero tandaan mo din na ganun pa man, it is your moral duty to be loyal and faithful sa partner mo. This topic is related to Anti-Wiretapping Act and the Data Privacy Act of 2012, which I will discuss in a separate video. I will put the link on the description box when they are already available. To end, please subscribe to our channel and stay tuned for more videos.